The Supreme Court issued its plurality opinion on October 1, 1948. Divided 4 votes to 3, the court struck down the statutes as unconstitutional. A young Justice Traynor authored the plurality opinion, joined by Chief Justice Gibson and Justice Carter. Although the opinion invalidated the statutes on various grounds, ranging from vagueness to equal protection, Traynor highlighted the personal nature of the fundamental right to marry. A member of any of these races may find himself barred by law from marrying the person of his choice, and that person to him may be irreplaceable. Human beings are bereft of worth and dignity by a doctrine that would make them as interchangeable as trains. Justice Carter wrote separately to say the statutes were never valid because they violated the supreme law of the land as found in the Declaration of Independence. Apparently appalled by the similarities between the rationale used to support the California statutes and Hitler's writings on preserving pure blood, Carter stated, "To bring into issue the correctness of the writings of a madman, a rabble-rouser, a mass murderer, would be to clothe his utterances with an undeserved aura of respectability and authoritativeness." Justice Edmonds, a member of the Christian Science Church, agreed that marriage was a fundamental right of free men, and proposed that restrictions on this right must confront a higher level of scrutiny. Specifically, the restriction is unlawful unless enacted to prevent a grave and immediate danger to a valid state interest. Justice Schenck wrote an extensive dissent, joined by Justices Schauer and Spence. The dissent expressed frustration that the state's power to regulate marriage could be set at naught by a majority order of this court arrived at not by a concurrence of reasons, but by the end of 4 votes supported by divergent concepts. Schenck noted these statutes predated our national independence and had never been declared unconstitutional by any court in any land. At its core, the dissent urged judicial restraint instead of invading the central province of legislative authority.